Good afternoon, everybody. This is New Keys to Freedom segment about trust basics. All right. First, it must be understood that any trust, regardless of many destinations applied to them, is in its most basic sense. A property interest held by one person, the trustee, at the request of another, the seller, for the benefit of a third party, the beneficiary. The classification applied to the trust is based primarily upon its mode of creation, in which it may be created either by act or party or by operation of the law. In the case of the former, trusts are divided into two types. You have an express or you have an implied. So creating a trust by act of a party, you got implied, or you can express. And when you express, that means it's written, or it is oral. So these are contract. This is contract law. This is what I study every day. I study law. Right now, I study business law. Okay, so without getting into the various subclasses of express and implied trust, the basic differences between one created by the express act of a party and one created by implied act of a party is that the former is stated fully in language, oral or written, while the latter is inferred solely from the conduct of the parties. These are very generalized definitions, so presented for want of space, since there are many intricacies concerning the true meaning of the term implied. It has been shown that in sense, the classification of express trust can only be applied based on what is implied by the language of the instrument which created the trust. So we won't get into that, but our focus is on a particular written express trust type. And even though the above definition is essentially accurate, it does little to define the express trust as it is known in its fullest sense under the protection of the common law. Express trust under the common law, the most adequate definition of express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition by a guy by the name of Alfred D. Chandler. Okay, and in the report submitted to the tax commissioners of Massachusetts on unincorporated associations, his study was conducted as part of a legislative investigation into their economic effect on the state in 1911. In the first part of the report, at pages 6 through 7, he offers the following definition of an express trust. Express trust: put the illegal estate entirely in one or more persons, while others have a beneficiary interest in and out of the same, but are neither partners nor agent. This simple, adequate common law right, any person or group of persons sui juris may exercise. The trustees issuing certificates of beneficiary and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. What becomes clear from this definition is that the express trust is not merely a property interest held by one for the benefit of another, like any basic trust, not like any, because you do have it's other trusts out there. And that's why y'all got to start understanding the instruments that the government are distributing to y'all, that the state are giving to y'all, so y'all can monitor these instruments. When they send you a car note or they send you a bill, remember I told y'all from past segments that those are vouchers. And those vouchers can be turned in to the IRS as a claim. Send it right on in. You don't have to send it back. You don't have to throw it away, screw it up. Get it, accept it for value, send it to the IRS and let them process it. You know what I'm saying? Because when the IRS send it to you, they send you a voucher and all you do is sign it and send it back. It's really paid. And that's what y'all finding out what's going on right now with everybody's, like, they got this new thing with who's God and what they talking about, and I don't understand. You probably not gonna understand nothing that I say today, and it's all cool. This segment is for the ones that pick up out there, and you got to remember, if you're trying to be something important, go on, step up to the plate. You can't half-ass. You can't sit up there and say, well, he ain't making me feel no. I'm not trying to do that. That's not my job. But I do want you interested, and I do want to help the ones that's around me. So what has been created here is a trust organization lawfully by natural right. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. Doing so requires no benefit, privileges, or franchise from any government or other outside party, and therefore the parties owe no duty to any government or other outside party to the extent that no common law criminal or civil wrong is the purpose of the trust. We're going to continue this segment. I'm going to just cut this one short. And again, as I try to share with y'all, it's important to pay attention to a lot of contracts that are offered out there from these businesses and stuff. But when done properly, the trust is afforded all the common law protection ordinarily given to the private contracts. Okay, so particularly the obligations of them. Now, the question is whether the parties to the contract are truly acting sui juris of their pure, unadulterated common law natural rights, because of if the parties import or associate benefits which grant an outside party a vested interest in the proposed contract, then the contract has acquired a third party overseer or either intervener. So a third party overseer is when we go in, a lot of time we like to register paperwork. We like to sign stuff and let the lawyer, or we like to let them. When you go in a store and you do these things and you get these little loans, you need to understand that that is a real contract. Because of that contract, that business will take the advantage of your ass. All right? And you have to build the trust, because the trust secures all of your access, no matter what. So if I take a trust and I build a trust and I get all my credentials that I go join to the state, like my license, Social Security, a car lot contract, my credit cards, and all of this, and get my credit right, you will have to put together a security agreement that covers all of your assets. And you're supposed to keep copies with you, and you're supposed to go downtown and to the domicile where you're from, and you're supposed to analyze that. You know what I'm saying? So that's what it is. This is New Keys to Freedom. I was just talking to you about the trust basics and the express trust under the common law. Another feature on the next segment that I will continue on, we will do a quick run through, which be the declaration of the trust. You know what I'm saying? So the declaration of the trust is the trust instrument that constitutes the trust. It has been noted in trust law that no technical expressions are required to create a valid declaration, so long as the words used make clear the settler's intent to create the trust or confer a benefit of some sort that would be best carried out in the form of a trust. A trust instrument doesn't necessarily need to be a declaration either, for a trust may be and often is formed out of a simple agreement or even a will. But when an express trust, the declaration has been preferred since the beginnings of trust under the common law of England, which otherwise shunned fictional law. This is where careful common law of England, which otherwise shunned fictional law, that is where careful attention to detail is most crucial, because in order to properly construe the intent of the seller, the object's property and manner in which all is to be carried out must be set settler. Fourth, in an ambiguous, precise language, so as to particularly create the express trust, and where the intent of the sellers is unclear. Under equity, interpretation is required to construe the intent of the parties, and the trust may be deemed invalid depending on the degree of ambiguity. However, when all is done properly, obviously there can be no lawful impairment of obligations of contracts. Again, I'm going to close this segment. I gave y'all 10 minutes. This is New Keys to Freedom. This is Sequel 1. Thank you.